What is a judge is actually sort of a more complicated question, I think, than you would normally think it is. In some sense, I often, when I'm thinking about questions like that, like to sort of go back to the beginning. Right? So judges were originally members of the king's household in England, and were really royal officials. They were sort of part of the administration of royal justice and the royal state. And gradually over time, they become more and more independent. And today we think of judicial independence as being sort of a virtue unto itself. And so we think of judges as sort of first and foremost people who are meant to settle disputes according to the principles of the law. Now that's the kind of answer that you would get from a very sort of what we would call formalist, a sort of very by the books type of answer. The truth is we know that a lot of what judges do is not all that different than what a lot of other political actors do. They bring to bear sort of public values on the questions that come before them, and they try to sort of think through resolutions to them. But they have their own sort of unique language, right? A lot of what sets aside a judge is the way that they talk about the decisions that they come to.
The Constitution sets up Articles 1, 2, and 3. Article 1 creates the legislature, Article 2 the executive, and Article 3 the judiciary. I think there's a reason that the judiciary is Article 3. They didn't think it was quite as important or as powerful as Articles 1 and 2. There's a reason Congress is first. That's, I think, in many people's views, that's changed over the last 200 years. But the judiciary was clearly third. And Article 3 says that the judicial power is vested in the Supreme Court and in other courts that Congress shall make. So we don't actually have to have any other courts if Congress decided not to. We could just have a Supreme Court. That has never been the case. Since the very beginning, Congress passed the Judiciary Act of 1789 and created some inferior courts, and then over time those have proliferated and we've had more and more. And the idea is that these are the courts that hear disputes that belong in federal court as opposed to belong in state court. So anytime a federal law is involved, anytime a treaty is involved, anytime the Constitution is involved, those cases go to federal court, and it's federal judges who hear them.
So I think you can think that there are sort of three main ways that Marshall goes about trying to build the institutional power of the judiciary. So one is the institution of opinions of the court, speaking with a single voice for the entire institution. The second, of course, is judicial review itself, the sort of claiming the ability to strike down acts of Congress for incompatibility with the Constitution. And then the third was the sort of Federalist Party as a whole had a certain idea of what federal judicial power should look like, and they were in favor of a sort of more expansive federal judiciary and a federal judiciary that had broader jurisdiction.
Marbury v. Madison was revolutionary for the power of the federal judiciary. Marbury v. Madison is one of the main reasons why Marshall gets the seat on the big chair in the marble statue in the bottom of the Supreme Court. Marbury versus Madison established that the court had real power and that it would exercise that power. It had power over the executive branch and it had power over the legislative branch.